Second phase of the Senate impeachment trial is underway. Now that both sides have given their opening arguments, senators are finally getting their chance to ask questions, sort of.
Mr. Chief Justice, I send a question to the desk.
Now, as the rules require, all senators are posing their questions in writing to Chief Justice John Roberts. Many of those questions are circling around the same issues: witnesses.
Is there any way for the Senate to render a fully informed verdict in this case without hearing the testimony of Bolton, Mulvaney, and the other key eyewitnesses, or without seeing the relevant documentary evidence?
The short answer to that question is no. There's no way to have a fair trial without witnesses.
If there are going to be witnesses, then the president would have to, in order, they said fair trial, fair adjudication, then the president would have to have his opportunity to call his witnesses. And there'd be depositions, and this would drag on for months. And then that's the new precedent.
Of course, the main witness in question this week is former National Security Advisor John Bolton, who wrote in a book, manuscript, leaked to the New York Times, that President Trump directly told him he was withholding aid from Ukraine until they help with investigations into the Bidens. But as some Republicans suggest they might be interested in hearing from Bolton, and the president's defense team looks to block that from happening, we're also learning the White House has been trying to block parts of his book from being published as well. In a letter sent to Bolton's attorney last week, that's before the New York Times published any of the manuscript contents, the White House claimed the draft contained, quote, significant amounts of classified information, including some at the top secret level, and they declared under federal law the manuscript may not be published or otherwise disclosed without the deletion of this classified information. So, now what? Joining me to discuss are former Massachusetts U.S. Attorney Don Stern. He also used to work in the Department of Justice alongside the man who went on to become Special Counsel Robert Mueller. Good to see you. Another former Mueller colleague, Bruce Singal, now a defense attorney, who was among more than 1,000 former federal prosecutors to sign a memo arguing the president obstructed justice as a result of the special counsel's findings and investigation. Good to see you, Bruce, as well. So it becomes increasingly unlikely that there'll be witnesses. 51 votes for witnesses goes back and forth. From what I've learned, 18 impeachment trials in U.S. history, 3 with presidents. 18 out of 18 had witnesses. This would be the first. Is there have you ever heard of a trial without a witness? Did you ever have one? I'm serious.
Not really, but the impeachment is not, strictly speaking, a trial.
True.
But if history is any guide, you're absolutely right. Witnesses are not only appropriate but necessary.
Let me read the question that Roberts just read. I think it was from Chuck Schumer. Is there any way for the Senate to return a fully informed verdict in this case without hearing the testimony of Bolton, Mulvaney, and the other key witnesses, or without seeing the relevant documentary evidence? What's the answer to that?
Well, the answer is the answer Schiff gave. The short answer is no. And a trial without witnesses is actually a misnomer. There's no such thing as a trial without witnesses. Witnesses are the essence of a trial, along with documents. And I think that's another thing that's been lost, that we don't have any documents, no emails, no text messages, nothing. Do
you find it compelling at all? Some of the president's lawyers today said, they're trying, I don't know if bootstrap's the right word here. The House could have called all these people. They didn't. And now they're trying to have us do their work. And again, it is not a classic court setting. So does that argument carry any weight with you, or no?
I think the Trump's lawyers have kind of moved away from strictly process arguments, and actually they're really not seriously arguing the facts anymore. They're kind of down to what I consider to be realpolitik arguments. Number one, the House screwed it up. Don't fix their mistakes. Number two, we're too close to an election, so let's not impeach the president. And number three, by the way, don't you make decisions based upon politics too? And do you want to be impeached?
I agree with Don's analysis, Bruce, but I have to say, the only one, it seems to me, of the president's team who's directly addressed the Bolton manuscript is a local guy by the name of Alan Dershowitz. Here, at least my summary of 3 of the legal arguments he's made in the last couple of days, and maybe each of you can tell me whether you think they have merit. He first starts saying that even if Bolton is to be believed, a quid pro quo is not an abuse of power. That's one in this case. 2, that an abuse of power is not impeachable even if there was an abuse of power. And number 3 today, I think this is the all-timer. Let's call it his national interest argument. Here's Professor Dershowitz.
They never allege that it was based on pure financial reasons. That's an easy case. That's purely corrupt and in the purely private interest. But a complex middle case is, I want to be elected. I think I'm a great president. I think I'm the greatest president there ever was. And if I'm not elected, the national interest will suffer greatly. That cannot be an impeachable offense.
Someone in the newsroom told me this. I have to say, in the spirit of full disclosure, I thought it was a joke. He's basically saying if I did what I did to get reelected because I believe my own reelection is in the national interest, quote, it cannot be an impeachable offense.
I assume that was a Saturday Night Live clip they were just showing.
Do any of these are, and once again,
okay,
even if the quid pro quo as described happened, it's not an abuse of power. Even if it did, an abuse of power is not an impeachable event. And now, if he's doing it to get reelected because reelection's in the national interest, he can't be impeached anyway.
Can I start with the third? Because that's
Sure.
the most fun.
Yeah.
It's ludicrous. If you are sacrificing the national interests in order to help yourself unfairly get elected, that clearly is something that, in my view, would be the type of abuse of office that the founders intended.
Well, Dershowitz says that is in the national interest, though. If you believe your reelection, he basically seems to me to be saying, Don, that if you believe that whatever you do will help you get reelected, and if you believe your reelection is in the national interest, then there's nothing you can't do.
I agree completely. It's ludicrous.
However,
it's not ludicrous if you think of who you're trying to appeal to, which you're trying to appeal to those senators who are sitting there thinking, you know, I often make decisions based upon what I think is in the national interest or in the interest of my state, but I'm also keep an eye on the election clock, and, you know, I don't want somebody sort of second-guessing my motives the way the House Democrats are now second-guessing the president.
So I know it's very dangerous to ask anybody to speak for Alan Dershowitz, but since he isn't here, let me just extend this final argument, the one today. It seems to me he's saying, even if he breaks the law, and if all 100 of you in this room agree that he has broken the law, if he did it to help him get reelected, once again, and he believes that's in the national interest, then you can't impeach him. That is his argument, isn't it?
That is basically the argument.
Okay, so can we go to something else that's driving me absolutely nuts? In my opinion, the Chief Justice, I've raised this a couple times in the last week, is acting like a greeter at Walmart, essentially. I mean, he has no function. You guys have read the pieces, Time Magazine, New York Times yesterday, saying preside in the Constitution means preside. It doesn't mean traffic cop. So Friday comes. That's the date they're going to vote on witnesses. 4 Republicans don't have it in them to join the 47 Democrats and vote for witnesses. They go down. Before the motion to dismiss, Adam Schiff says, Mr. Chief Justice, I've got a motion. My motion is that you subpoena John Bolton in the interests of justice, in something, and you have the power. Does he have the power to do that?
I would say he has the discretion to do it. The problem is it's not clear what the presider in an impeachment trial has the actual power to do because those powers are undefined. But clearly,
well, it's not clear he has the power. It's not clear he doesn't have the power.
He has the discretion. He is declining to exercise that discretion because he wants to be seen as even-handed and not making a decision which would alienate either Democrats or Republicans.
You buy that? I mean, does he have the power?
I think he definitely has the power. I think he should exercise it, but he won't.
But how can he preside? How can Roberts, who everybody says, even his detractors, as a matter of politics, say the guy deeply cares about the institution? How can he preside over a case? I mean, let me read to you. In their brief that was filed last week, the president's lawyers, not a single witness with actual knowledge ever testified the president suggested any connection between announcing investigations and security assistance. He knows there is somebody of great repute, the former national security advisor, who is that person who suggests there's a connection firsthand. He knows he exists, and he'll allow a trial to conclude without that witness being called on?
I agree. Well, I had the same thought. There were different portions when the Trump lawyers were making clearly misstatements of fact, clearly misstatements of fact, which everyone knows were not true. In a trial, as Bruce knows, there's the opportunity for either the judge to interfere and to say, counsel, by the way, where do you get that? Is that based on the record, or for an objection to be made? But I think the impetus to avoid politics and to avoid being placed in the middle is what I think is driving him to sit like a stone and only basically provide a perfunctory role.
I want to seize quickly, if I can, on the thing you said about the lying. And also, again, when they filed this brief, there was a January 23rd letter from someone on the National Security Council to the lawyer for John Bolton saying the thing I read before, you can't publish it. They knew when they wrote this brief that there is someone out there, admittedly, he didn't testify before the House, so it's not technically untrue, who was a person who had direct information. Is that keeping information before the court an ethical problem for these lawyers?
Well, I think it's potentially an ethical problem. The question is this a search for the truth or not? And I think we all understand it's a political process. It is not a search for the truth. And in terms of your question, Jim, about the Chief Justice's role, really the only decision he has to make, the fundamental decision, is do I make the decision as the presiding judge here, or do I leave those decisions to a vote of the entire Senate body? And he has clearly chosen the latter.
And you don't think there's any part of Roberts that is saying to himself, I'm not going to get involved in this witness issue if they're voted down. And in whenever it is, March 17th, when the book is released, and it is clear to every fair-thinking person in America, even if they support Donald Trump's presidency, that this was directly relevant to this proceeding. You don't think he worries about the consequences of that, Roberts says?
I think he worries more about being embroiled in a political food fight. You know, he has quoted Justice Rehnquist's remarks at the Clinton impeachment, which is I had very little to do and I did it very well, and I think that's what he aspires to do.
But I learned from Chuck Todd from Meet the Press last week that in the Andrew Johnson impeachment there was an activist judge. Right. So 1 out of 2
Chief
so
Justice
far,
Chase in the Johnson
Johnson
impeachment did take a more activist role. And the Senate rules, and I read that op-ed in the New York Times with interest, the Senate rules do contemplate the Chief Justice having the power to issue subpoenas.
Okay, 15 seconds. We've done legal. Let's do political. Is there a vote for witnesses on Friday or no?
No.
How about you?
I think yes.
Hope you're right. See you. Bruce, thanks so much for your time. Don, as always. Appreciate it.